Court is now open. You may be seated.
Good morning.
SJC-09704, Commonwealth versus Hensley.
Mr. Graham, good morning.
Good morning, Your Honor.
You may proceed.
Thank you. Please the court, I am Stuart Graham, counsel for the defendant, Kevin Hensley. In this appeal from his conviction for first-degree murder, Mr. Hensley has raised a number of issues in the brief. However, I hope to address two of them during argument. The first is whether the testimony of the expert pathologist violated Mr. Hensley's Sixth Amendment rights. And second, whether trial counsel was ineffective at trial for failing to introduce available psychiatric testimony in support of his mental impairment defense. Let me state my premises first on the Sixth Amendment argument to set the context for it. We assert that the Sixth Amendment required the opportunity to cross-examine the medical examiner in this case before his findings in the autopsy report or expert opinion based upon those findings could be admitted. Therefore,
Could you just refresh my memory? Now, why didn't the medical examiner testify? Had he gone to another jurisdiction?
I don't know, he had
Took a day off.
didn't
I
he?
think he was out to lunch or had a day off or something like that. There was no legitimate reason for his not being there. In fact, he was scheduled to be there. I think everyone intended that he would be there. Therefore, it was error to allow the expert to recite the findings from the autopsy report on direct examination absent the testimony of the medical examiner. This court decided that in Commonwealth v. Nardi.
Was the cause of death in this case contested?
No.
Doesn't that make a difference under Nardi?
I don't think it makes a difference because the pathologist gave opinions on a variety of subjects, all based upon the findings in the autopsy report. That is, he gave opinions which formed the foundation for the Commonwealth's argument of deliberate premeditation and extreme atrocity and cruelty. Those opinions were the length of the struggle, the type of the struggle, the method of death.
Let me ask you about those things. It was Dr. Flumenbaum who testified.
That's correct.
So did he give his opinions on those things, or did he simply recite the opinions of others?
He basically recited the findings in the autopsy report, and then he would say what those findings meant. Other times he would give his own opinion. For example, his opinion on cause of death was strangulation by ligature.
Do you mean when you say he cited the findings in the autopsy report, he would say the autopsy report says, or Dr. I forget his name,
Zane, I believe.
Zane. Dr. Zane found, I mean, is that how he phrased it? Or I mean, in other
Yes.
words, it wasn't based on his review of a photograph or something like that?
He only saw two photographs that was in the record, and they were not relevant to any of the issues upon which he testified. In fact, it was doubtful whether they showed bruising. That had to be confirmed by tissue studies on the inside of the throat. He didn't review the slides themselves. He only reviewed what the autopsy report said about them. So he would be asked by the prosecutor, what did the findings show? He would then relate the findings. Then he would be asked about them, and he would give an opinion based upon those.
So is your concern not that cause of death was at issue, but that extreme atrocity was at issue, and his testimony went to that issue?
His testimony went to both premeditation, deliberate premeditation, and extreme atrocity and cruelty, as well as the cause of death. We think the Commonwealth has the obligation to prove cause of death beyond a reasonable doubt. Without the medical examiner, the actual cause of death, I don't think, could have been proven, although there was circumstantial evidence, but as cause of death is a particular topic within the expertise of the medical examiner.
I
So
don't
we think
get-
all three issues.
I'm not following you. You told Judge Botsford that the cause of death was not contested.
It's not contested in
That-
this,
It's not contested that she was strangled. It is contested as to how long it took and whether it showed premeditation.
That's
Is that your
correct.
point?
that's correct. So I think on those issues alone, reversal would be required under a harmless error standard. I note the Commonwealth argues that the objection here wasn't preserved, trying to bring themselves within Commonwealth v. Nardi. However, I think the objection was clearly preserved. When the pathologist was offered for testimony,
Didn't he say, preserve, I don't have to do this again? I mean, didn't defense counsel say to the judge, note my objection and I'm not going to object again, is that okay, or words to that effect? Or am I thinking
his-
another case?
well, his first objection was that this is neither the person who did the autopsy
Right.
or authored the report, therefore I object to the entire testimony.
Right.
That was his objection. Later on, when he would testify, he said, note my objection, don't have to repeat it again, and the judge said, fine. So
Was
he
it-
objected to the entire testimony, both the opinion and the findings.
And was it both sort of DYS versus juvenile as well as Crawford? Or, I mean, did he articulate
He did not articulate
what the objection was
the
based on?
precise standard, but in this context, it's clear it's a criminal case. He's objecting to hearsay testimony. This court has determined autopsy reports are testimonial, so it's testimonial hearsay. The Sixth Amendment grounds would be obvious. Even a general objection, I think, would suffice in this case. I would indicate that in Davis v. Washington, when the affidavit was offered, trial counsel stated that this doesn't give us the opportunity to cross-examine the person who drafted it. That was sufficient to preserve the constitutional objection on Sixth Amendment grounds to that affidavit. The objection in this case was even more specific, but I think it's clear that it was adequate to preserve the issue and to alert any reasonable trial judge to the evidentiary and constitutional basis for the objection. So the harmless error standard would apply, giving the Commonwealth the obligation to establish beyond a reasonable doubt that any error was harmless. I note in their brief the Commonwealth did not address this issue, so they have made no showing.
I mean, this didn't address the standard issue? I mean, whether it's
The harmless
harmless error or
They didn't address the
substantial
harmless error standard. They argued only that the objection wasn't preserved, so it's a likelihood of substantial harm. That's all they did. So we think that the recitation of the findings of the medical examiner on direct examination in this case by itself, under the harmless error standard, would be sufficient for reversal. Secondly, and Nardi, I think, establishes that. The second issue is allowing the medical examiner to provide an opinion, and several opinions in this case, based upon those findings. Now, Nardi seems to hold that one of three bases for an expert opinion would suffice. That is, if the opinion is based on facts within knowledge of the expert, facts admitted in evidence, or facts that are proper to rely on and independently admissible. I would note that the first two grounds do not obtain here. That is, the expert had no personal knowledge of this case or the facts in the case, and he was shown and testified to no evidence that had been admitted at trial. That is, in the questions given to him, the prosecutor did not say it's been testified or assume and recite any findings. So his opinion was based upon the autopsy report. He was shown two photographs, which, as I indicated, did nothing to establish any of his opinions. In fact, by themselves were not sufficient to establish that they were bruising. He had to do that by looking at the report of the tissue slides. By the record, by the transcript, we know what he reviewed, the medical examiner's file. That was his testimony. That included a hearsay report of the incident, some autopsy photos, some photos of the body, but we don't have any of that in evidence. Thus, there's no way to know if it was proper to rely on those.
Well, now, hold on. We do know what he relied on, right? We do know what he relied on. You just recited it. The autopsy report, photos, you said hearsay reports. So each of those bits of information would be independently admissible, wouldn't they? If witnesses were called in to testify to them, they would be admissible.
Not the autopsy report.
No,
Right,
no.
the autopsy report
No,
would
no,
not.
what's in the autopsy report, if the medical examiner had been called, the one who actually did the autopsy, he would be able to testify to what he wrote in his autopsy report, what he observed, et cetera, right?
That's correct.
So it is independently admissible. That's the point.
My argument is that the construction of independently admissible, as set forth in Nardi, Department of Youth Services, and Marquardt, violates the Sixth Amendment. It violates.
All right, so an expert cannot rely on things that may be hearsay, as he relies on them, because he's relying on reports of others.
That's correct.
Right? Even though those others could have come in and testified appropriately to exactly what was in their reports.
Correct. That is precisely what the Sixth.
Experts do this all the time.
But
How
that is-
can you possibly say that they can't rely on such information when that's what experts rely on?
Prior to Department of Youth Services, experts didn't rely on that. Prior to Department of Youth Services, the law in Massachusetts for probably a century was that an expert had to rely upon facts within his personal knowledge or admitted in evidence. Department of Youth Services changed that. So we're dealing with that only since that time, and Department of Youth Services did not address the Sixth Amendment implications in that change in the law.
Mr. Graham, from your point of view, would it make a difference? Department of Youth Services, and I don't have the case with me, but my memory is that it's not an autopsy report, I know that, but assuming it's an autopsy report, that the person who prepared the autopsy report was available at trial, correct?
I'm sorry, I don't have a memory of Department of Youth Services that precise.
It seems to me that must surely make a difference. That is to say, if you go along with Justice Cordy's correct position, and the person is there that can be cross-examined, then you don't have a Sixth Amendment problem, or do you?
Not if the Commonwealth puts that person on to testify. But to shift the burden to the defendant to have to call that person, I think that violates his Sixth Amendment right.
You don't disagree that the federal rules of evidence go even beyond Department of Youth Services?
I agree, Your Honor.
And
In fact, Department of Youth Services...
Are you aware of
limited
any federal case that is found since Crawford that this practice of experts violates the Sixth Amendment?
This practice under the federal rules, which have been adopted in a number of states, has been called into question in some cases, and specifically in the Arizona case to which I referred the court in my letter, State v. Moss, found that it would violate the Sixth Amendment. It does it for two reasons. The first is it's facts properly relied on. Right? That means there's a judicial determination of reliability. The court or rule of evidence determines that the facts upon which the expert relied are reliable. That was a law in Ohio v. Roberts, which was overruled in Crawford. Reliability is to be determined through cross-examination, not by a rule of evidence and not by the court. That is done away with now. Crawford actually, to some extent, overrules the federal rules of evidence in that sense. To the extent that the federal rules of evidence allows in evidence that would violate the Sixth Amendment, it has to give way. So when the court determines that certain facts are reliable enough for an expert to rely on, rather than having those facts subjected to cross-examination, which Crawford says they has to be, that violates the Sixth Amendment.
Well, that was the purpose of my inquiry, to say, regardless of whether you think the autopsy report would or would not be admissible, or the expert could or could not rely upon it, if you've got the expert there, right? I mean, then you don't have a Crawford problem, and then you don't have a Sixth Amendment problem.
That's right. If the
I mean,
expert-
so I at least have to get you to agree with me to that extent.
If the expert testifies, you have no problem. I agree with that.
Okay, and so regardless of whether or not in a particular case, whatever the expert relied upon is reliable or not.
Yeah. If
Correct.
those facts can be subjected to cross-examination at trial, that's the way reliability is now determined. That was not the case at the time of Department of Youth Services or the adoption of the Federal Rules of Evidence. Crawford changed that.
So an expert simply cannot rely upon the reports of anyone else with respect to various tests or any of the components that an expert would ordinarily rely on in forming an opinion. Can't do that anymore.
He can do that
You've
if
gotta
they're
call
offered.
all you've got to call all of the underlying persons who performed all of the reports in to testify, to get all that into evidence. Then you call the expert to say, what do you think about that?
That's correct.
And that's a Crawford requirement.
That's correct.
And would that also apply to when experts rely on literature, that you'd have to get the authors of all the literature on which they are relying?
Well, the literature would not be testimonial.
How about
It's only when the facts that the expert relies on are testimonial hearsay that they have to be subject to cross-examination. There's a lot of hearsay that is not testimonial.
But an opinion could be equally based on, I mean, that seems sort of, in this sense, a distinction that I'm not sure makes a lot of sense. In other words, an expert could totally form his or her opinion based on, meta-analyses in lots of literature, and you're saying that would be fine,
That's correct.
even though nobody's decided whether that stuff was reliable or not.
Yeah, I would,
But if you put fact there, then it changes character?
when you put testimonial hearsay or testimonial fact there, that implicates the Sixth Amendment. I would refer you to the discussion in State v. Moss and the discussion in Wigmore's new treatise on evidence,
Okay.
both of which address precisely that point. And my argument is based upon, in part, what Wigmore and State v. Moss
Mr.
require.
Brown, let me see if I can flesh this out. And maybe I'm not understanding you, but I want to make sure that I do. The medical examiner, not this case, hypothetical, the medical examiner is told that the police discovered the body at midnight, right? And he uses that as a fact. So he knows that by midnight, he bases his opinion on the fact that by midnight, the victim was deceased. Right? You're saying that he cannot rely on that fact without the police officer being called in to testify, I discovered the body at midnight and I took the signs and...
At trial, the police officer would be called to testify to that fact.
You say would have to be called.
Yes.
Okay. If he says, I was told that the victim was deceased by midnight, and the police officer comes in to substantiate that, and based on the literature or whatever it is, when I did the autopsy report, which was at noon, I can take into account changes in the body that would occur within 12 hours. You say you don't have to call in the writer of the treatise.
That's correct.
So that's how you would make the distinction.
That's correct.
Okay.
And again, I would again stress, it's testimonial facts that have to be subjected to
I understand.
cross-examination.
So what you're essentially saying is if the medical examiner who did the autopsy has died, moved away, you simply can't get evidence in with respect to the cause of death from another expert, unless there was somehow an exhumation and a new autopsy or something like that.
And
What's the answer?
if I'm correct on this, most all
is the
autopsies
answer
have a
yes?
second pathologist.
Is the answer yes to Justice Cordy?
If there is no other pathologist.
Okay.
Yes,
And no other pathologist who witnessed the...
who witnessed it. And, or if the autopsy was not videotaped, which could provide a new expert with the opportunity to see what he's talking about.
I'm sorry, a new expert that would be able to see, so photos aren't enough.
Photos aren't enough. Photos have to be authenticated.
As were
And
filmed.
a photo, in this case, for example, Justice Cordy, he saw 2 photographs of bruising on the neck. His testimony was, I couldn't tell whether they were bruising until I read the report of the tissue studies of the inside of the throat. That confirmed they were in fact bruising.
Who did the tissue studies, by the way?
The medical examiner.
Or a lab person in the medical examiner's office?
As far as I know, it was a medical examiner. There's no
So
indication
you'd have the same
differently.
trouble even with the videotape, because the videotape isn't going to show what you need to show in the tissue
It may
studies
not.
either.
But you would, if you had a lab person do the studies, you could call that person in. You know, Melendez-Diaz is before the Supreme Court now on the issue that Justice Cordy raises.
We are aware of that,
Yes,
Mr.
I know
Graham.
you are. And that will clarify a lot of how far down you have to go as to
I know
lab
you
studies.
I know you have state against Moss, but Crawford is 2004, so we're 4 to 5 years later. And, I mean, the facts of this case, that is to say, the administrative facts of this case, that the medical examiner wasn't available, or, you know, somebody else wasn't available, are not exactly unusual in the criminal justice system. It happens all the time.
It does.
I mean, we have several cases.
It shouldn't, but it does.
Well, we have several cases today, and I can't imagine that Massachusetts is any different in that respect. And yet this still hasn't bubbled up through the federal district courts. There hasn't been a challenge in the federal district courts.
I haven't seen a challenge. As I say, I brought State v.
It
Moss.
may just be that counsel in Massachusetts are better prepared than anybody else. I mean, I'll concede that.
It could be.
Well, there certainly have been, some states permit the simple introduction of the autopsy report without witness, and I know that's been challenged.
Yes.
Well, that's really
Some
what the-
states don't, some states do, and I think that's going to be decided.
Well, surely that the Melendez-Diaz
Right,
case
that'll be
will-
decided
will
there.
decide that.
Yes.
And that will presumably also go to Justice Botsford's point about whether the lab technician, if it was not the medical examiner who performed the
The tissue
tissue studies,
person
and if
have to come in.
and if the Commonwealth or the defendant wants to introduce the tissue studies in evidence.
Yes. So,
As you know, Mr. Graham, the flashing light actually means something around
yes,
here.
I'm ready to pick this up and sit down. Thank you, Your Honor.
Thank you very much. Good morning, Ms. Celia.
Good morning, Your Honors.
It would be very helpful to me, Ms. Celia, if you, why don't you introduce yourself just for the record?
Thank you. Good morning, Your Honors. May it please the Court. Kathleen Celio on behalf of the Commonwealth.
It would be very helpful to me if you could address the preservation of the error, because it might make an enormous difference in this case.
Well, actually, I was going to start with that.
Thank you.
Defense counsel did not save this objection under Crawford, under cross-examination. If you look on page 85 of volume 4, that's what he says. He says, this is neither the person who conducted the autopsy or who authored the report. He never says, I want to cross-examine that person. My rights to cross-examine him have been denied. He gives an objection which I've tried to interpret, and I don't really know what he meant with that objection. He just meant that he didn't author the report.
Could you think of any other reason why he had the objection?
Isn't that really a question about cross-examination, much more than the evidentiary point?
No, I mean, I don't, if you look at based on even the way this was tried, I don't think so. I think, in fact, I point out in my brief, he actually benefited from Dr. Flummenbaum not testifying, because his whole attack on extreme atrocity and cruelty was because the Commonwealth presented an expert who didn't know anything about.
We can't get to that point. We have
Okay.
to decide. I mean, you may be correct,
Yeah.
but that's not the way the analysis will proceed. I mean, we have to decide whether or not Dr. Flummenbaum could testify and to what extent. But forget about that. It seems to me that we would be. The objection arises in the context of the unavailability of a witness.
No, that's correct, but I draw your court's attention to Nardi, because in Nardi, the defense counsel was very specific about his objection to the opinion of the medical examiner who testified. And that was preserved, the opinion was, but then in looking at it, you said that him reciting the underlying facts, the objection didn't preserve it for that part of his testimony. And so, and you said you need to look at it in the context of the trial.
And in the context of this trial was that nobody knew, except the Commonwealth maybe had a little advance notice. I mean, everybody expected Dr. Zane to show up.
I think the Commonwealth expected Dr. Zane to show up.
No, I mean,
also.
everybody did, but the judge did. I mean, the judge, who is this person? I mean, he wasn't
Right.
even on the witness list. I'm summarizing the judge's comment. The defense counsel didn't know. The Commonwealth proceeded perfectly appropriately. In other words, it got another medical examiner.
Right.
But it's very difficult for me to think that this isn't a preservation.
I mean, I draw this court's attention to Commonwealth versus Fowler. I mean, I cited in my brief 431 Mass, 30, and they said although the defendant objected to it, he didn't object it based on constitutional grounds. And I would think that in this situation, you have, he would have to state that I want to cross-examine Dr. Zane, and I don't think he preserved it. And I think what's really telling is that the way the defense counsel tried this case, he did not want any of the pictures introduced into evidence, because the pictures tell a story that is a very gruesome beating strangulation. There were 11 pictures introduced into evidence. There are exhibits 11 through 13, 52 to 57, and 64 to 65. In introducing the exhibits of the pictures in 52 to 57, they were introduced through Detective Coleman. And there's a brief sidebar where defense counsel is fighting to keep out pictures of the victim. And the same thing with Dr. Fogelbaum. The only reason Dr. Fogelbaum only got to see 2 pictures and talk about them is because defense counsel objected and limited the amount of pictures that Dr. Fogelbaum could refer to of the victim.
Well, you're going to prejudice. You may. I mean, that's an argument. I assume that you would say, even if it is harmless error, it was harmless beyond a reasonable doubt.
Well, and I also think that it's the Dr. Fogelbaum. If you read his testimony, it does track the findings of Dr. Zane. But what he did see is the pictures of the autopsy, and they're very clear. This is all external bruising. I mean, this is all external injuries. And it was very clear of the injuries. And I think that if we go down the line of, well, a medical examiner could never testify to, any findings or base his opinion on those findings, there's going to be a lot more introduction of autopsy pictures, autopsy photos of the victim in situations like that. Because I think it would have really helped the Commonwealth if Dr. Fogelbaum could have referred to more of the pictures of the victim.
This may not be your point, but I'm wondering whether your point about what defense counsel focused on is sort of harking back to Nardi, the fact in Nardi that the defense counsel wanted and used the facts, the underlying facts, because it was helpful to his. I mean, it was his theory of the case. Is that what you mean? That this theory of the case really didn't go to cross-examining? I'm just not sure whether maybe that's what you mean. That if you're looking at context, this defendant really was focusing on something totally different, and actually benefited from it.
The findings were based, were recorded of the photos of the victim, and the external injuries were really not of dispute. They were depicted in the photos, which he really tried to prohibit many of them going to the jury. And I think that in this situation, defense counsel, I'm saying he benefited from it, he used some of Dr. Zane actually, his findings to impeach Dr. Fogelbaum because he was making opinions. Some of his opinions were, I know that there's scratch marks.
Whose opinions, Dr.
Fogelbaum. I mean, he made opinions. I know that they were the victim's scratch marks because it's usually the victim who's trying to claw at the tie and not the perpetrator. And this was unobjected to. I mean, this is not anything that Dr. Zane would have written in his findings. This is Dr. Fulmenbaum interpreting things that were depicted in the photos.
Let me ask you this question. With respect to premeditation, because I take it that was a theory that was also found by the members of the jury, how did the autopsy report figure into that, if at all?
I guess you would say that the more he, the fact that he strangled her for 2 to 10 minutes showed that he really intended to do it. I mean, I can't say that it didn't help, but I mean, we premised our premeditation based on his statements to his friends,
right,
saying, I intended to kill the victim and then I'm going to kill myself.
And he left work early, specifically went to the house?
Yes, he went when his kids wouldn't be there. So in that way, I mean, we were relying on that evidence.
The 2 to 10 minutes, was that based, that's from Dr. Flamenbaum, right?
That was based on
what?
the pinpoint hemorrhaging in that actually the jury could see in the photos. What showed a pressure differential, and that the tightening and the claw marks on the neck showed that she was trying to take it off, that it would get tighter. The jury also had a picture of how tight the tie was. It was incredibly
that
tight.
Opinion, if I'm understanding correctly, that you would say that opinion or those opinions that go to premeditation or something else really were based on Dr. Flamenbaum's opinions based on what he saw in the photos. Is that correct?
I mean, yes. I mean, he refers to facts, and there's times in his testimony, and it's very hard. There's times in his testimony he says, well, the findings said X, and then he goes on for 3 or 4 more pages about, different scratches, and so it's hard to tell, I don't know what he had in front of him. I know he had the autopsy report in front of him, but I don't know what else.
If we read it, Ms. Celia, and I understand that you're in the same position that we are, because you were not trial counsel, right?
No.
So I take it that once you say this is what the autopsy report says, and then it goes on to the 3 or 4 pages, is Dr. Flamenbaum, could we infer that he's talking about sort of general information, not on what he's looking at, or is it clear that he's based it on whatever the autopsy report said?
I feel like it's unclear. I mean, because he'll go on about something and he'll say, well, it's the pinpoint hemorrhaging and this is what happens when there's pressure differential, things that he's just talking about. I mean, that wouldn't be in the findings, and he explicates to the nth degree.
That a pathologist with his knowledge and experience and training would know about. If you see this kind of,
correct.
If you see pinpoint pricks in the left cheek and there's a ligature around the neck,
right,
seeing those pinpoint pricks would mean that certain events were taking place.
Correct.
Okay.
And the reason, and I guess the reason why he didn't refer to more pictures is because defense counsel didn't want him to. I mean, because those pictures were bad. They were very damaging. I mean, he refers to them in closing argument as gory. I mean, I urge.
This was not an easy death.
This was not. And I also want to draw this court's attention. My brother cites State v. Moss, an Arizona case. I actually looked at Arizona actually allows that involves I think toxology reports, but Arizona actually says that a medical examiner can make opinions of autopsy results that he did not do, and that's State versus Smith. It was decided 2 days after State versus Moss, and State versus Moss in appellate court in Arizona, and this is the Supreme Court of Arizona, and it's 215 ARIZ 221, and it was authored in May of 2007, and it was 2 days afterwards. So Arizona allows, Arizona's opinion is consistent with what this court held in Nardi. And so, unless the court doesn't have any questions on that, I guess I would like to address Dr. Rosmarin's, whether or not it was ineffective for not presenting Dr. Rosmarin's testimony.
In the motion to suppress?
At trial.
At trial.
Sorry.
At trial.
And I think the standard here is whether or not it was manifestly unreasonable. And I think if you look at volume 4, it was at the end, he had presented the defendant's sister. Defense counsel is speaking with the court on page 175, and he's speaking with the court, and there's a possibility that Dr. Rosemarin is going to testify. And he asked the court whether or not he can get the instruction on mental impairment. And pretty much gets insurance that he's going to get the instruction, and then at that time he doesn't call Dr. Rosemarin. And so I think that it was reasonable for him, being told by the judge and having gotten the instruction and being able to argue it, that it was reasonable to not have the expert testify. And also,
Why?
Because I think it was reasonable for him to think that Dr. Rosemarin wouldn't have benefited his defense. I also draw this court's attention to pages 175 and 166. The Commonwealth would have presented, depending on how well Dr. Rosemarin did for the Commonwealth or not for the Commonwealth had an expert ready to go also. So it's not like we wouldn't have kind of countered any evidence that would have been, it would have been focused on whether or not the defendant, could deliberately premeditate. And I also think that...
I'm sorry to interrupt you, but was that fact that you had your own expert who would presumably testify if Dr. Rosemarin did, was that known to the defense counsel?
Oh, yes. And if you look in the record, but also on page 76, the defense attorney and the prosecutor's we weren't allowed access to, our expert had already examined the defendant, but we weren't allowed to know anything of the facts, obviously, anything that he told the expert. And so we just knew her conclusions. And so on page 176, there's a discussion about, my expert's going to come tomorrow. Can she sit during, Rosemarin's testimony? Because I want to, she needs to be prepared. So we were ready to go with an expert if we felt it was necessary.
The judge also relied on the fact that, and the way it's written, it wasn't clear to me that that if Dr. Rosemarin had testified, the defendant's medical records would have come in.
Well, he bases in a part of his opinion is based on the medical records.
Okay.
And in his motion for new trial, and I think on appeal, he's saying it was ineffective for him not to present the medical records either.
There's also something else I believe I read that what would have come in through Dr. Rosemarin's testimony was a description given by the defendant of what happened in the house.
That is very correct. And
was that sort of consistent with the Commonwealth's theory? Why would that have been a bad thing? I take it wasn't contested really that he had committed the crime.
Well, no, it wasn't. But I think if you look on page, it's on the defendant appendix 111. The Commonwealth's theory was the defendant did this out of anger. He did it out of rage, and he came there with the intent to kill her. If you look on it, this is a statement that the defendant made to Dr. Rosemarin. I was just so scared. I wanted to run out. I was afraid I might beat her up. I was in the changing room next to the bathroom. She walked in. She said, "What are you doing here?" I grabbed her. We both fell down. I started choking her, saying, "You destroyed me and my family." Just choked her. And then he goes on and he says,
This is the defendant's statement.
yeah, I was going to take my life and I blamed her for it. So it fills in details that I think would benefit the Commonwealth. It shows that he was angry.
Details far beyond what he had told police officers that came in as part of the Commonwealth's case.
Yeah, he actually didn't testify. His statement was that it was all a blur of whether or not he went into the house. So there was no statement of the defendant placing him in the house.
Without the only evidence is really these inferences that Dr. Flamenbaum drew from the pressure pinpoints right? In other words, it was a creation of what happened based on the forensic medical evidence.
Well, and based on where the blood was, there was blood in the second floor, and then she was found.
But no witnesses were testifying.
Oh, no. And I think that, and what defense counsel did, bring was, it was very sympathetic. All the witnesses testified very sympathetically towards the defendant. And there was evidence that he had been depressed. His daughter testified that he was on Celexa, and that, it was understandable. His defense was he was a good father, he was a good man, and he snapped when the divorce happened. And he doesn't, he accepts responsibility, but he doesn't deserve first degree, only deserves second degree. And I think it was reasonable based on the evidence and, that he had before him. And I guess also I just say that I ask this court to not, to decline to use its power under 33 in this situation. The defendant intended to kill the victim, and then he intended to kill himself. And it's a case of domestic violence, and I just ask this court to affirm the jury's verdicts of murder in the first degree under both theories.
Thank you, Ms.
Thank you.
Celia.